Families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Thank you for joining us for this week's edition of Families Divided. Sadly, many issues involving children whose parents don't live together are not easily resolved between the parents. That's when attorneys and the courts have to get involved. Today, attorney Robert Hoffman joins us to talk about managing these cases of parental alienation in court. Plus, later in the program, attorney Shazia Sparkman will be here to talk about enforcement of court orders in parental alienation cases that are in the best interest of the children. We'll be back with attorney Robert Hoffman right after these messages.
Divorce and co-parenting are a major life interruption for families, especially the kids, but also for parents and grandparents. And it's even worse in blame-filled, high-conflict cases. When parents engage in alienation by turning the kids against the other parent or grandparents, kids suffer. They're denied the opportunity to build the 4 big skills necessary for future resilience. New Ways for Families online class can help. Parents learn to use our popular BIF and EAR skills to calm the conflict and stop the hostile emails and texts. And we even have a class for kids and parents to learn together. Research shows a 75% improvement in joint parental decision-making after this course is taken, plus overall improvements for kids' well-being. Don't wait to make this affordable investment in your children's future and improve your well-being too. Start learning new ways for your family today at conflictplaybook.com.
Hello, everyone. I'm Jennifer Parker, the author of Coercive Relationships, Find the Answers You Seek. An attorney once told me that abuse can affect victims in ways that hurt their cases. I wrote Coercive Relationships in order to help survivors in better understanding how they've been affected and to learn coping strategies. This book is also helpful for professionals because it helps them to better understand their cases. This book is available on Amazon or wherever you like to buy books. Thank you.
Often, dealing with the issue of parental alienation can seem like trying to untangle the biggest rope in the world. You don't have to untangle parental alienation alone. The Exo Foundation offers help through empowerment, equity, and education. Find out how the Exo Foundation can help you by visiting theexofoundation.org.
It's my pleasure to be speaking to you today about litigating and managing a case involving parental alienation. There are a number of components to this topic, which I'll try to outline and cover in the brief time that I have to speak to you today. Primarily, the aspects are centered around the lawyer himself or herself preparing herself for handling a case of this magnitude, and then also helping the client manage the stress through the different steps and procedures of a case involving parental alienation. It's important at the outset to realize that parental alienation cases are very different than traditional high conflict child custody cases. This is not simply a case of he said, she said, and whoever's believable is the winner, if you will. This is a case that is very different. It's a scientific case. It's a case that requires a tremendous amount of expertise on the lawyer's part as well as expert witnesses' parts. And it's very important to educate the judge or jury in the case about what a parental alienation case is. And the reason why I say this is there's many aspects of a parental alienation case that are counterintuitive, meaning they're not what we would normally expect. Normally, we would expect a child or children who are rejecting a parent that there must be something really wrong with the parent causing the rejection or the failure to establish a relationship. In this case, we have to educate the judge and the jury to let the fact finder know that there's a very different dynamic going on here. And it starts from the very minute the client walks into your office, to the development of the case, to the preparation for trial, and then ultimately the trial itself. This is not a case where you can use intuition. Intuition may serve you well in different types of family law cases, but it's not a case where you can sort of trust your heart or trust your gut or trust your experience, even if you've been litigating for a number of years, in order to effectively handle a parental alienation case. Intuition alone is not going to get you very far. We must show the fact finder that the child or children are rejecting the parent or grandparent, either contact or a relationship, because of the undue influence and efforts of the opposing party. And that's really where the focus needs to be in this case. And there are many ways to help establish this in an effective way for the fact finder. Again, this case should be handled, or these types of cases should be handled as if they are scientific cases, medical cases. You need to have very experienced expert witnesses who can help develop the cases, can point out the facts and circumstances that are different from a traditional child custody case or a high conflict child custody case, and help explain the counterintuitive nature that while the children are rejecting the targeted parent, there are facts and circumstances which require probing and analysis to be brought forth. And once they are brought forth and a light is shown on them, to show what the true causes of the rejection and the fractured relationship are. I find many, many times that even very seasoned, experienced trial lawyers, family lawyers, do not have the expertise and the experience in the area of parental alienation. So I would make sure those of you who are clients or potential clients seeking counsel, that you ask very probing questions about your counsel, prospective counsel, the experience, the number of matters they've handled, their familiarity with parental alienation, to make sure that you've got someone that can really help guide you through this very difficult area. Also, with respect to parental alienation, it's very important that the lawyer recognize what a parental alienation case looks like. So you want some basic elements. You need to be able to establish that there was a prior good relationship between the child or children and the targeted parent. You want to be able to establish that the children are rejecting a relationship or contact with the targeted parent, and that they're doing so because of the undue influence of the other parent. And you want to understand how are alienated children different from children who have suffered actual physical or, heaven forbid, sexual abuse. They present very, very differently. What are their manifestations, and what do these children look like? And how can you help explain that to the court or to the jury? Also, there are a list of common, well-documented, well-researched, well-established strategies that parental alienation takes form, if you will, that alienating parents employ in order to alienate children from the targeted parent. So you want to be able to structure and develop your case from the beginning to identify that this is a case of parental alienation. Number two, to conduct your discovery, both in terms of the written documents that are sent out, the subpoenas that you issue for medical records, therapeutic records, police records, Children's Protective Services type records, juvenile records, prior allegations that have been filed, and whether they've been founded or unfounded. You want to get a very comprehensive history, excuse me, to be able to put your case together. You also want to be able to understand the elements of parental alienation, again, both the manifestations in the children and the strategies employed by the alienating parent in order to be able to organize and persuasively present your case to the judge or to the jury. It's critical in these type cases that you have qualified experts, and most mental health professionals, while they may be very good at what they do, are not qualified experts in the area of parental alienation. I am astounded and surprised over and over again with very credentialed and experienced therapists, psychiatrists, mental health professionals who get it completely backwards and again assume that if a parent is being rejected by a child, it's because that parent must be doing something very wrong or very bad. And many therapists are entrenched in the idea that traditional therapy is the way to solve this. And actually, traditional therapy makes oftentimes the relationship between the children and the targeted parent even worse and reinforces the negativity that the children are experiencing in the alienating parent's home. So there are a select number of trial lawyers across the country that have this requisite level of expertise. There is a select number of mental health professionals across the country that have this requisite experience and expertise. And I think it's really important, to the extent that you can search and locate and associate yourself with folks like that, it's going to make all the difference in the world in your case. Now, one area that I think probably requires a little further discussion would be in terms of managing or litigating a case involving parental alienation is working with the mental health professional. I think that it's important for you to have, if the case warrants, two mental health professionals who are expert in this area. The first one can speak at the beginning of the case as a generic witness, sometimes a little bit case specific, but to educate the court on what parental alienation looks like, how to rule it in, how to rule it out, how it is a form of very serious child abuse and can seriously affect children. What are the signs and symptoms and manifestations and factors to look for, and to orient the court from the very beginning of the case that this is not, again, a traditional case and needs to be looked at with different lenses and different glasses. I think you then also need, ideally, you can't always have this combination, but ideally have a case-specific witness who has done a forensic review of all the documents, all the depositions, all the records, all the pleadings, all the text messages, and all these things, by the way, need to be gathered through the discovery part of the case, who can specifically talk about how the facts and circumstances of this case meet a mild, moderate, or severe parental alienation diagnosis. You're going to run up against a number of tried and true attacks, if you will, on parental alienation. Number one, saying it's really not recognized. That's not true, because you can find ample support in almost all jurisdictions of cases that have published, court cases that have published and upheld parental alienation as being an appropriate analysis of the family dynamics in the case. You should certainly have those cases ready for your particular jurisdiction. You should be prepared for a judge who says, or opposing counsel who says, we can try this case in an afternoon or maybe 1 or 2 days at most. If you only have 1 or 2 days to try a parental alienation case, you almost certainly will lose. You really need 5 to 7 days, and sometimes even more. You're going to need a day on each of the parents or parties. You're going to need at least a day on an expert witness and a half day on the first expert witness, the generic witness. There's going to be collateral witnesses. There probably are going to be mental health professionals on the other side. And it's very important that there's adequate time to develop and present your case, again, which should take a week and oftentimes more. Selection of mental health professionals is critical. There are many resources, including Family Access, that would list certainly some of the top professionals in the country in this area to assist on cases of this magnitude. You cannot simply rely on the court-appointed custody evaluator or the child's treating therapist, or one of the parents' treating therapist, and assume that that person has any knowledge, let alone any knowledge applicable to effectively prosecuting or defending a case involving parental alienation. So very important that you get your mental health professionals lined up early and work with them carefully, and they can guide you as to how to conduct your discovery, how to take depositions, how to examine witnesses, and how to present your case at trial. Let me talk in the time that I have remaining about the other part of this topic, not just litigating a case involving parental alienation, but managing a case involving parental alienation. I have found, working with many cases and many clients who are targeted parents or grandparents across the country, that almost uniformly the targeted parent or grandparent comes across or presents or exhibits anxiety, agitation, anger, pretty much what can be perceived by those that might not know the person and what they're going through as kind of negative emotions that may turn off certain people or push them back. It's going to be the lawyer's job and other members of the team to work with the client to help tone that down as much as possible. Not every time when a client or a targeted parent or grandparent speaks to a mental health professional or a minors counsel or an amicus attorney, or to the court and to other professionals, the drum doesn't have to be beaten so loud that no one else can hear in the room, screaming and shouting about the injustice of it all. And I think it's important for the lawyer to work with the client in all the various areas that the client has to interface with the mental health professional, maybe with a custody evaluator, maybe with a children's protective services investigator, investigating allegations of physical abuse and other types of abuse, how to testify in depositions, how to testify in court. You just can't assume that your client knows how to do these things well and correctly. And yet I see constantly clients who it's readily apparent that they've not been prepared for what they're doing. I see them on the other side, or I see them, they come to me as a second or third lawyer, and I realize that they have had their clock cleaned, so to speak, because they just haven't been prepared. So there's two mantras. One is prepare for the lawyer to make sure he or she is adept and up to speed with all of the themes and issues involving a parental alienation case. And that same mantra of prepare applies to the lawyer's duty to prepare the client throughout the whole process. I go through very elaborate pre-deposition, pre-hearing, pre-trial preparation with my clients so that it's not just theoretical, it's actual. I will do mock direct questions and cross-examination questions. I will speak about the themes of what is trying to be conveyed. I'll speak about the negative aspects of the case, of which there always are some, if not many, negative facts, bad facts, and how to address those. We'll talk about likability, excuse me, how to present well, eye contact, body language, word choice, speaking in a good cadence, proper tone, very solid knowledge of the facts and counterattacks that the client is likely to receive. And oftentimes we'll even do some videotape practicing of these skills. And it sometimes takes 2, 3, 4 or more times to get a client comfortable enough to be able to set aside as much of the passion and emotions, negative passion and emotions that drag the targeted parent down, and to channel that into positive energy and emotions to be a likable, credible, persuasive witness at trial. I think in sort of wrapping up my talk, I think it's important to step back at the beginning of these cases and map out, literally chart it out on paper, which witnesses will be used, what documents are going to be helpful in the case. What are the negative facts, and what do we have to refute those facts, or what witnesses do we have that maybe can rebut or impeach statements that are made by other parties. Look at the motivations for the alienating parent acting or in a certain way or saying the things that he or she is saying. Dig deep. I think it's important to dig deep in these cases. I don't leave anything, to the extent that I can help it, any stone unturned, so to speak. I think it's very important that you thoroughly and completely investigate the facts of the case. I think it's important, as I've indicated, to prepare your client and prepare yourself. And, I would say, don't be shy to raise your hand, whether you're the lawyer or you are the client, and say, something doesn't seem quite right here. If you're the client, I'm not getting the kind of feeling and confidence from my lawyer that he or she is truly versed in this area and is properly leading me through it. Speak up. And if it doesn't change, then you may need to change to a lawyer who is trained and has expertise in this area.
Our thanks to Robert Hoffman for his insight into alienation cases in court. When we return, Attorney Shazia Sparkman will talk about enforcement of court orders in parental alienation cases.
In families dealing with alienation, communication during conflict is often very difficult. This fall, Family Access, Fighting for Children's Rights, will present a special in-person conference to address that very issue. Using and Refining Interpersonal Skills will be held September 9th through the 11th at the Marriott Research Triangle Park in Durham, North Carolina. You'll learn from experts how to master skills that can reduce anxiety, anger, and stress in alienation situations. Join Event Director Elaine Cobb, the founder and president of Family Access Fighting for Children's Rights, and conference moderator Dr. Colleen Murray as they present a lineup of highly respected experts, including keynote speaker Dr. Jeffrey Gardier, plus presentations by Bill Eddy, Megan Hunter, Dr. Joshua Coleman, Dr. Mark Mosk, Dr. Mary Alvarez, Dr. Sue Kornbluth, Shazia Sparkman, and Lisa Rothfuss. Mark your calendar now, September 9th through the 11th, for Using and Refining Interpersonal Skills, hosted by Family Access Fighting for Children's Rights, Steel Partners Foundation, and PA is CA, Parental Alienation is Child Abuse. Visit familyaccess.info for more details on the conference and secure your attendance. Seating is limited.
At Victor's Crown, our focus is on you, our clients. When you arrive, our goal is that you will feel at home, from our welcoming atmosphere to our serene surroundings. Everything we do at Victor's Crown is done with our clients in mind. We have comfortable seating areas for both adults and children. A large screen TV with surround sound where clients can be occupied with wholesome entertainment while they wait. We offer complimentary refreshments such as coffee, tea, water, and snacks. Due to the present COVID pandemic, our in-person appointments are restricted to selected cases, and those are held in our luxurious outdoor open-air meeting space that we affectionately refer to as the COVID Cabana, which was built specifically for our clients to offer them the most comfortable and relaxing outdoor space available. All our other clients are offered secured web-based telemed sessions where they can connect with us from anywhere in the world.
In a recent webinar, attorney Shazia Sparkman talked about dealing with the enforcement of court orders in parental alienation cases.
When those orders are finally enforced and the courts do act, it is a direct promotion of the best interest of the children. And how? Going back to connecting the dots for the courts is so important. How do we do it? We want the courts to identify parental alienation early. We want them to ask for these assessments and seek these assessments early. We want them to case manage and clear their dockets for cases where there's allegations of parental alienation within the courts. We want there to be strict requirements and parameters entered and vocalized that will occur if orders are not complied with. We want the courts to step up and limit the number of continuances, delays that are caused, and identify with a level of emotional intelligence when delays are being used or orchestrated by the favored parent and in what fashion. This is when case history, if it's available, becomes so important, as it was in this case. One reading of the docket and one reading of the prior plethora of court orders in that case was sufficient in order to lay down strict requirements that there would be no other delays.
Miss an episode of Families Divided? Watch previous episodes and more on our YouTube channel, Families Divided TV.